Okay, 係咪夠?
Is it the case that we have formed a quorum? Welcome to the meeting of the Bills Committee. This is the third meeting. Item 1. Application for late membership. Dr. Elizabeth QUAT has written to Arts on the 30th of October. She hoped to join the Bills Committee and take part. In accordance with House Rules 23B and C, if there is a late membership application, unless there is indisposition or absence from Hong Kong when a member is supposed to signify his membership, well, that late application has to be accepted by the members of the Bills Committee. Any views on Dr. QUAT's application? Agree? Yes. Welcome, Dr. QUAT. All right. Let's go to the agenda proper. Let's invite the administration team to join us. I'd like to remind members that in the last meeting, actually we held a public hearing, and today we will continue scrutinizing this bill. Members can ask questions. We will not start clause by clause scrutiny yet today, so you can still raise questions on wider policy issues. There are 2 papers tabled. 2 organizations have written to us. Actually, one is from the Federation of Beauty Industry and the other is from Dr. P.N. Chan. So these 2 papers have been tabled. After the last 2 meetings, the administration has given us several papers. Members, please note these papers. And today we have from the administration team, Mr. Fong Ngai, Head Health Care Planning and Development Office, FHB. So can Mr. Fong take us through the latest papers, please? Thank you, Chairman. Thank you, members. In relation to the last meeting on the 9th of October, over 30 deputations and individuals have given views on the bill, and we are grateful for their valuable views. And we have analyzed the views collected, and we have made a response to some of the issues, and that is outlined in paper number CB bracket 2196 stroke 1718 bracket 02. So I would now like to highlight the salient points. At the last meeting, representatives from the faculties of medicine of the University of Hong Kong and the Chinese University of Hong Kong expressed a view that facilities managed or controlled by the faculty should not be regulated under the bill. We note that there already exists robust governance mechanism for Hong Kong U and CU Hong Kong, so we are inclined to accept their suggestions. So to this end, we propose to introduce an amendment to exclude any facility which meets the following criteria. 1 is managed or controlled by Hong Kong U or CUHK. B, that is the facility is a day, procedure center, clinic, or health services establishment, and that means that would exclude private hospitals. And C, primarily used for teaching or research relating to medicine or dentistry. Second, some deputations have asked about the offenses under Clause 12. When we consider whether a person has committed the relevant offense, we will have regard to factors including the facts and other circumstantial evidence. We would not be concerned as to whether the medical treatment is for beauty purpose. Rather, we would be mindful about the risk and that these procedures should be performed by medical practitioners or dentists. And some deputations have given views on the 2-tier complaint mechanism. Some believe that the Independent Committee on Complaints should carry certain features. They have given us different views. And after we have considered their views, I think the present proposal has ensure the balanced participation by different stakeholders to increase the transparency, neutrality, and credibility of the committee. We consider that the composition now, and that is at least half of the members should be lay members, and that they should not be medical practitioners or dentists, would be able to meet with the above objective, and that should be enough flexibility in the composition of the committee. Some deputations said that there should be appeal mechanism. Well, we already have a two-tier mechanism already, so that we don't think there is a need to add an additional appeal mechanism to prolong the complaint handling procedures. Some believe that that there should not be a restriction on the 2 years time frame or time limit on the complaints. Well, we have taken reference from the hospital authorities' complaint mechanism and drawing up that time frame. We think the approach is appropriate. As to the application fees for hospital licenses, now for private hospitals, nursing homes, and maternity homes registration, under that ordinance, some nursing homes may aspire to become a private hospital in due course, and they are very concerned about the application fee. Now, if the existing nursing homes would like to become a private hospital, they would be required to pay a lower fee tantamount to a license renewals. So we are considering if the wording of the bill should be refined to make clear this policy intention. As to emergency situations under Clause 68, and that is a PHF must not provide to a person a medical procedure that may require the person's continuous confinement within the facility for more than 12 hours. Some deputations that the government should give flexibility, and people under emergent situations should be allowed to stay in the facility for a period longer than expected. We have consulted the DOJ on this, and the way it is written will allow for unexpected and emergency situations where the operator will not be considered as violating Clause 68 if a patient has to stay in the facility to undergo urgent treatment. Some of the views that the scope of small practice clinics should be broadened, while there are calls of further tightening of the definition of small practice clinics. We had to strike a balance in setting the exemption threshold in respect of small practice clinics. We have conducted extensive consultation on this, and we believe that the definition of small practice clinics in the bill has taken full consideration of the views from all sides and is appropriate. On transitional arrangements, some deputations that there should be ample transitional period should be available so that the stakeholders can get ready for the new regime. I have to explain here, to ensure that operators and the medical and dental professions will be fully prepared before implementation of the revamped regime. We have provided for transitional arrangements. For example, when the new legislation is enacted and takes effect, the director will, if satisfied that certain conditions are met, issue a provisional license to the operator of an existing day procedure center or clinic after receiving the operator's applications for a full license. The provisional license allows the day procedure center or clinic concerned to continue to operate before it is qualified for the full license. We will also commence the regulatory regime in phases, with the regulatory regime of riskier types of private healthcare facilities put in force earlier. The relevant prohibition and offense provisions will be effective, and we consider that both the public and stakeholders are ready for full-scale regulation in respect of the type of PHFs concerned. We think that we would also be providing exemption for specified nursing homes. Now, lastly, someone from the beauty sector expressed concern about the bill. Actually, last week we have met with the beauty sector's association. Some members also attended that meeting. And at the meeting, we explained to the beauty sector the provisions of the bills. We have collective views on their concerns. We would try to continue to listen to them. And lastly, I would like to thank the deputations and stakeholders for expressing their views. We'll continue our dialogue with them so that we can further improve on the implementation of the new regime. Mr. Fong, on the 11th of July, we have also raised certain questions, and you have already responded to those. Can you also take us through those points? I meant the issues raised at the meeting on the 11th of July. Do you have the relevant papers? Because in the last meeting, that was a public hearing, meeting with deputations. So we haven't asked you to go through your response to our issues raised at the 11th of July meeting. So can you go through that?
Thank you, Chairman. This is CB2-2140/16-17(02). It was tabled at the last meeting. Now, firstly, what's the medical service under the bill? Now, in relation to a patient, this is defined under Clause 2 as a medical diagnosis, treatment, or care for the patient given by a registered medical practitioner or a registered dentist. Such medical treatment or care may be given directly by the dentist or doctor, and for example, if a medical practitioner gives a direction to a nurse over the phone regarding a treatment or on a patient, the treatment delivered could be considered as medical service under the bill. Second, nursing enforcements. Now, staffing requirements or healthcare personnel vary by type of facility. Under the existing system, for certain specialties in a private hospital, the staffing requirements are prescribed in the codes of practice for private hospitals, nursing homes, and maternity homes. Given the evolving medical technology and diversity, it is desirable for the regulatory authority to adopt a similar approach to prescribe staffing requirements for PHFs where appropriate in the form of codes of practice. And we also touched upon the two-tier structure on complaints and on the class of specialized service. Now, last time we talked about the hemodialysis case. The working group on defining high-risk medical procedures, practices performed in ambulatory settings set up under the Steering Committee on Review of Regulation of Private Healthcare Facilities recommended that hemodialysis be classified as a high-risk medical procedure which should be performed only in regulated ambulatory facilities or hospitals by qualified health professionals. It was also recommended that hemodialysis in the form of continuous this kind of treatment should be performed in hospitals only, and the recommendation was endorsed by the Steering Committee and formed part of the regulatory proposals when the government consulted the public. Under the bill, scheduled medical procedures can be performed in day procedure centers but not in clinics. Hemodialysis is now listed in Schedule 2 to the bill and is a scheduled medical procedure when carried out as an ambulatory setting. So there are 4 members who wish to ask questions: Chen Pu-yin, Kwok Ha-ki, Shu Ka-fai, Chen Chi-chun. 5 minutes each. Actually, it should be Chen Kin-po first. So, Chen Kin-po first, 5 minutes. Now, I'd like to talk about the views of the Insurance Industry Association and another insurance industry organization. Now, the regulatory authority should be an independent authority, and it should regulate the ambulatory centers, and it should further promote electronic medical record system, so that the transfer of records is more smooth. Now, for the consumers, they are concerned they are concerned about how much they should pay when they leave the hospital. Now, the government has some estimates, but it's not very helpful. Very often the doctor fills out the part for the doctor, but not the part for the hospital. Now, you can't force the hospital to fill out that part, so the estimate or forecast is not that effective. So try to make the hospitals fill out their part, and also the private healthcare facilities should establish schedules of fees, preferably as a package. Now, different hospitals charge fees on a different scale, so people cannot compare. Now, it's also suggested that we should learn from Japan and Malaysia and so on. The regulatory authority should take the lead, and based on the information from the industry in the past, come up with a schedule of fees, and we should take the averages and over 1 or 2 years, and the insurance industry can use that as reference. Now, the Alliance of the Insurance Industry has questions listed. Can you provide a written response for all the questions and comments? Please reply to the questions on policies. Mr. Fong, we thank Mr. Chen for his views. We agree totally that we need to regulate PHFs through this bill. Now, the execution department will be the Department of Health. Now, we agreed that the electronic medical record system should continue to be developed, and on the transparency of fees charged by hospitals. Now, in the bill, we have such a clause requiring that the hospital should, in accordance with the DOH requirement, adopt transparent measures. Now, earlier we introduced a pilot scheme before this bill becomes effective. Now it has already been in operation for about a year. Now, under the pilot scheme, there are 3 measures. First, an estimate of the operation fee and the fee of schedule and data on the fees charged. So this is actually answers Mr. Chen's questions. Now, on the budget estimate, the current approach is that the doctor stationed at the hospital should fill out all the information. Now, if it's not inpatient service, we are working on that. Now, about 60% in the second quarter, 60% of the operation procedures did have the budget estimates filled out, and we will try to improve on that. Secondly, on the other 2 items, transparency of fees charged, in principle, for the 11 private hospitals, they have disclosed on the internet their main fee schedules in accordance with DOH requirements, and they also provided historical statistics on the fees charged. And some hospitals provided more data than the DOH required. I will ask in the second round. Dr. Chen Pui-yin. Now, to follow up on my question last time I also asked about this, and my letter today expresses concern the government's response that the regulation on the two universities will be exempted. Now, private medical facilities, they came and spoke to me. Now, why are they concerned about this? Because for the regulation of PHFs by legislation, now in the medical academy, they offer the views, and some of them are from universities. And then you tell us that some of the establishments under the universities will not be regulated. So it seems rather odd and perhaps doesn't seem fair. Now, looking at the appendix to the document, there are 14 lists. Now, in 1512, there are the first stage clinical trial centers. They are for research. Now, however, there are other establishments. I investigated them. Now, the document says that they are mainly for teaching or research purposes in medical science and dentistry. Now, these lists are mainly in relation to private charging of fees in the private sector for outpatient service. Now, we mentioned that when university staff they patronize private doctors, there are time limits, and private operations in universities, are they regulated? And if they are indeed for research purposes, they should be exempted, but some are not for research purposes. Now, the document also says, I will let you have time to respond. Now, it says that the regulatory mechanism has been effective. Now, I'd like to know what's the mechanism and what are the details, how it has been effective. Head, the head. Now, first we like to explain. Now, the PHF bill says that there are certain PHFs, but they exclude medical institutions not under the hospital authority. So the Queen Mary Hospital and the Prince of Wales Hospital, they are not regulated under this bill. So the two under the two medical schools of the two universities, now they are not regulated. They do not fall under the regulation of the bill for certain reasons. Now, because they are mainly for teaching or research for medical science and dentistry, and now if they are directly managed and controlled by the universities, if they are private. So we will go and talk to the institutions concerned. Now, what do you mean by main? Is it 60 or 70%, 60% or 70%? Now, staff are taking on private cases. Now, we have to sort out now about the bill. Now, the two universities will have affiliated hospitals. For instance, there will be one for the Chinese U. the hospitals are regulated under the hospital authority. Now, in the future, there may be an establishment. It says it is not part of that hospital. It's an establishment under the university. So it's very troublesome. The head. Now, I will supplement. Now, if the two universities manage or control a private hospital, then they are regulated under this bill. There is no exemption. Now, what we have been talking about is that these medical institutions under the two universities, whether they are dealing with private cases, whether they charge fees. Now, this is not what we are dealing with because when they do teaching, they also charge fees. Now, so whether they charge fees or not, that's not a criterion. Now, Mr. Fong says that he will go back and get information from the universities.
So when we have further information next time, we can discuss that. Dr. QUAT. Mr. Fong, I have a question for you. On what basis would you grant exemption to the universities? I think it's important that we treat everyone equal. Now, if you say that the two universities will be excluded today, then different organizations will come forward to apply for exclusion. So what is the rationale behind? Now, the regulation is there to protect Hong Kong people. And we're not having an assessment, say, of the value of different institutions. So what is the basis for taking away this protection for patients treated by university hospitals? So why are you doing this? You should treat everyone alike. You want to protect Hong Kong people, the members of the public. You are not here to protect the two universities. So if the two universities are faring better than we expected, so there is no reason why they should evade the regulation. You are now creating this privileged class. But the bill is there to protect members of the public, not the two universities or yourself. Have you consulted the public? Why you are taking away their protection? I will give the full 3 minutes for Mr. Fong to respond. Thank you, Chairman. Thank you, Member, for your question. Like I said, the PHF bill is not there to target hospitals or clinics under the HA, and for the proposed exclusion for the two universities, we have set categorically clear that they are used for teaching or research relating to medicine or dentistry. Well, please let him finish. My chairman, well, he's just halfway through his answer. You don't need him to answer. Mr. Fong, why did I ask this? This is very important. Because we all know many of these clinics are taking on private cases and they are charging patients, whether it's at the dental clinic or the two institutes under HKU. They are very different from HA's clinics. They don't have a conflict of interest. But for these clinics, you know that the persons in charge are allowed a share of the fee. So there is indeed a conflict of interest. And the bill aims to afford better protection to patients. So if you had said the president that these universities can be excluded, then that's going to be very dangerous. Why are you taking away these universities from your regulatory regime? Have you consulted the patients, people served by these universities' facilities? Have you asked them, consulted them? Are you finished with your question? Yes. Mr. Fong, in the public hearing last time, representatives of the two universities raised this request. And at that time, patients groups didn't have any particular view on that. Mr. Fong, well, don't be so treacherous in a way. While we have listened to members' view clearly, we will be consulting the patients' groups. No, it's just not the patients' groups. Patients' groups don't represent all citizens of Hong Kong. Maybe you can come up with a scientific way to ask the views of the members of the public. Can you take the initiative to survey the people patronizing the two universities' facilities? Before you introduce the bill, you have conducted some 70 consultation sessions, right? Can you say something about that? Yes, indeed, we have convened 70 sessions. This is a new proposal. So in response to the members' request, I have said that we would consult the patients' groups on this. I am raising this because this is a significant issue. I must reiterate. We are not looking at whether these facilities are free charging. Rather, we are looking at whether they are primarily used for teaching or research relating to medicine or dentistry. That is our focus. In any case, I undertake that we would be listening to views of the major stakeholders. On this issue, you said that you would seek further information when you go back. Maybe on this issue, we can discuss further next time. Mr. Peter Xu, I would like to thank Mr. Fong. I have met with the administration together with the beauty sector, and we understand more about the bill and how it will impact on the beauty services sector. I reiterate, for clinics which practice medical procedures, I support there should be regulation. But for the beauty services sector, they have great concern. Let me cite an example. One of the things that will be regulated is that, say, if a doctor appears in this beauty parlor, then the beauty parlor has to appoint somebody like a chief medical executive who should be registered. But if this beauty services parlor is a chain store and they have, say, 20 to 30 outlets, then they are asked to appoint a chief medical executive. Then it's all understandable. But then for some beauty services parlor, it may be a solo practice, 1 or 2 outlets only, and most of the services are beauty services, but maybe some Botox injection will also be provided. But for these invasive procedures, they have to be performed by doctors. And when they receive such a service request, they will ask a doctor to come over and perform the operation. Then if that is the case, then that beauty parlor will be considered as a clinic. And if that is the case, they have to appoint a chief medical executive. So there is this scenario. If this doctor is stationed there all the time, then that's no problem, and he will take on the responsibility. But then the doctor may be going around to different beauty parlors, say on Monday to 3 p.m. There are 2 clients. He will be there to perform the operation. But for the other periods, he will be going to other clinics and beauty parlors to perform other operations. So for this beauty parlor, if it has to seek a doctor to be the chief medical executive, then it's very difficult for them to do so. In your paper, you said that at the most, the chief executive, the chief medical executive can service 2 beauty parlors. But then some thousands of beauty parlors will need that service. And we know that there is a acute shortage of doctors in Hong Kong because people often patronize A&E ward. So it will further aggravate the shortage of doctors in Hong Kong. Just like in the past period when all the mainland women were coming to Hong Kong to give birth to babies, we were also seeing an acute shortage of doctors. So can the doctors be serving as the chief medical executives of more than one facility, say maybe at 5 or 10 facilities? Secondly, now if there is a doctor in the beauty parlor, it is deemed a clinic. Now the beauty parlor was originally providing, say, a massage service and so on, and it is turned to be into a clinic. It needs a separate access, and that's very strange, right? Would there be a middle sort of approach, a middle course approach? Because the beauty parlor may not be very big, so it's very difficult for them to set up a separate access. Now, on the question of eyebrow tattooing, and if you ban this tattoo paste, then it's going to be a problem. And if only doctors are allowed to use tattoo paste, eyebrow tattoo paste, and that is going to be difficult because they have to ask a doctor to help with this kind of procedure. Dr. Fang, as I said in my opening remarks, the bill does not target the beauty services sector. We are really targeting the medical procedures which have to be performed by doctors. So whenever doctors are involved in performing certain medical procedures, they should come under the regulation. So beauty parlors should not be regulated under this bill. But in the actual operation of the beauty parlors, we know that sometimes they may need to engage a doctor to help perform some of the services, but that usually doesn't take long. So we will further consult the beauty services sector to see if there is further room to allow the beauty services sector to go on with the operation. Mr. Peter Shiu was asking 2 questions about the licensee and also supervision. Well, the bill says that a doctor can only serve as the chief medical executive for 2 clinics only. So I'm asking whether that number can be raised. And Mr. Fong seems to be saying that he will study into whether there can be relaxation. Another question is on the access of the beauty parlor. Now, if a beauty parlor is turned into a clinic, then it needs a separate access. Now, and also that's the tattoo paste, and also, well, I'll leave that for the second round. Mr. Raymond Chen, thank you. I'm also concerned about the issues raised by Koka Ki and also Dr. Pian Chan. In paragraph 2 of the government's paper, that it says the government will exclude the 2 universities. So that the bill would not stifle the teaching and research activities. Can you give us a paper explaining why, if they are brought under the regulation of the bill, their teaching and research activities will be stifled? That's number 1. Number 2, are there outpatient clinics run by the 2 universities? Will a fee be charged? Do you understand those aspects? And if there are serious incidents, who is going to take responsibility? You said that there already exists robust governance mechanism of Hong Kong U and CUHK in respect of PHFs. Dr. Pierre Chen said that he doesn't know what this mechanism is, and he has written a long letter to ask the government to give us a detailed explanation of what the mechanism is, and also a copy of the relevant document should be provided. So he's asking about whether the mechanism has been effective, and what is the do they have a complaint handling mechanism? What is the number of complaints? If we they can't give us an answer. They must provide supplementary information. Now, paragraph 14 says that the government thinks that the 2-year restriction period for submitting complaints is appropriate. Some of the view that this restriction should be relaxed. So can the government tell us, say, if that the complaint was launched after 2 years, why is it that you can't allow for relaxation after hearing the views? Why are you so adamant about this 2-year restriction period? Can you give us a more detailed explanation? Is it because after 2 years, some documents got lost and it's difficult to deal or handle the complaints? I think that can be handled because the later the complaint was lodged, the less chance that it would succeed. But why is it that you have to stick to this 2-year restriction?
The exemption of UHK and CUHK, we will provide a document next time. Now, on complaints as mentioned in the beginning, for the 2-tier mechanism, this is in reference to the 2-tier mechanism adopted by the HA, and they also use a 2-year limit for complaints. Now, I hope that when there are complaints, they should be submitted as early as possible, now, so that the information can be at hand. Now, we think 2 years is appropriate. If it's more than 2 years, they can lodge civil claims and so on. Now, we think the complaints mechanism will be more efficient. We think this is based on the experience of the HA. Now, can you provide us with information on the basis for the adoption of the 2-year period by the HA back then? We will try to look at whether there are guidelines established at the time. Dr. Elizabeth QUAT. Now, I still don't see why the 2 universities should be exempted from regulation. I hope there can be clearer explanation why the exemption should extend to the clinics under the 2 universities. Now, I also had meetings with the beauty industry, and I share Mr. Shiu's concern how to avoid impacting the functioning of the beauty industry. The administration said that they will try to reduce the impact on the beauty industry. Now, if you do not provide us with sufficient information on how to reduce that impact, it will affect our scrutiny of the bill. When can you provide us with the document? Now, Mr. Shukafai mentioned the tattoo paste issue. Now, it is related. Now, the tattooing of the eyelashes, and now you don't let it be used by the beauty parlor. You ask that it be used only by the doctor, and that will be problematic for the beauty industry. So now, concerning the tattoo paste, I'd like to invite the Department of Health representative to speak. Now, Dr. Chu, now this is about regulation on the basis of premises. Now, on the use of tattoo paste, this has to do with regulation of medicine. Now, this has to be with reference with how the material is acquired, so it has to be with reference to the regulation of medicine. Now, the question is, if one uses tattoo paste, then does it have to be a doctor? And if it's a doctor, will there be regulation? Now, we've been talking about the beautification process. Now, on the use of the toothpaste, it has to do with the regulatory legislation on medicine. Now, if it's used on patients by a doctor, that is, of course, okay, but can ordinary citizens buy and use it? Now, the administration hasn't considered the needs of the beauty industry. Now, tattooing, eyelashes, and eye outlines, profiles, lines, these have been long-standing practices, and recently operators of beauty parlors have been arrested. You said you require this to be done by a doctor, and then you regulate them. So this leaves little room for them to survive. So you need to have overall consideration. It mustn't be piecemeal, because this bill affects the survival of the beauty industry. Now, on the use of the toothpaste, anything to add? We will go back and we will supply you subsequently with information on the toothpaste. Now, on how the beauty industry is not affected, now will you provide us with further information? Will you discuss with the industry? Mr. Fong, we are discussing this issue internally. Please let us have some time, and we will try to have some response before the next meeting. Okay, I think we need an answer before we go into the clause-by-clause scrutiny. Dr. Joseph Lee, on the regulation of universities, I'm very puzzled. I don't quite understand. Now, the universities seem to be to have been exempted. So these would be private institutions or premises. So will they be unregulated? Supposing a university operates a private hospital, so is it totally unregulated, or is it same as other private hospitals and regulated the same way? And how are private hospitals being regulated currently? Now, the administration says that the universities offer service, offer research, offer teaching, so the private hospitals that they operate will not be regulated at all. Now, private hospitals should be under the Department of Health. Now, this is my concern. The public is concerned, so the universities can operate as many medical establishments as they like. Now, the members of the public will be concerned. Now, if you have other legislation regulating the universities, that would be okay too. Now, on the beauty industry's concerns, now Mr. Xu says that some beauty parlors. Now, this bill regulates healthcare facilities. Now, in some beauty parlors, doctors work there 2 hours a week. Will they be treated as a healthcare facility? Now, if I operate a beauty parlor, if you treat me as a healthcare facility, then you treat me as a clinic, and I have to get a clinic's license. But if I only have a qualified healthcare professional there a few hours a week conducting some healthcare procedures, will I be treated as the operator of a healthcare facility? But the bulk of the operation is on beauty. So this should be clarified. Otherwise, there's a lot of confusion. Now, if the doctor is resident there, then of course, if he is there 8 hours a day, then of course it has to be treated as a clinic. Also, I'm puzzled by the toothpaste question. Now, if the doctor writes me a prescription and gives me a container of the toothpaste, well, or he writes me a prescription for me to buy one, and of course I can apply it as much as I like. So I don't see the problem. So the government shouldn't be so rigid. It says it's got nothing to do with this bill. It says it's under the legislation for medicine. Now the tattooing is a long-standing practice. Now, and there are exemptions. So these matters should be clarified so that the public knows when they wish to get some tattooing done, they can go to Dr. Shiu and they can buy tattoo paste without being arrested. The head. Thank you. Concerning the two universities, it has been made quite clear already. If private hospitals are operated by the two universities, they will not be exempted. What we are talking about is exemption, daily the ambulatory centers or health service centers for teaching or research purpose. Now, if it's only a couple of hours a week that the doctor comes to a beauty parlor, now we don't focus on the number of hours he's there, or whether there is a medical procedure taking place at the premises. If there is, irrespective of the period of time it's administered, it will be regulated, because it has to do with the health risks of the public. Now, concerning the toothpaste, we will go back and get the information on the requirements regarding such medicine. Dr. Fernando Cheung is not in the room, now not in the chamber. Chen Kim-po, second round. Now, the consumers face this issue. Now, the budget estimate comes too late. Now, one is facing surgery, and then he is told the amount. Does he dare to change the surgeon? Now, 60%. Now, the doctors are prepared to fill it, but the hospitals are unwilling to fill it out. Now, when you actually implement the provisions, you should be very careful. Perhaps the government should take the lead. Now, you should put it in writing clearly so that the public can make compatible comparisons. Now, the services should be comparable. Now, the hospitals should follow the same standards. Now, I'm just expressing the concern of the patients inpatients who don't get any information on the fees they will be charged until they are actually discharged. The head, Mr. Fong. Now, when the bill becomes effective, there will be codes of practice where such requirements would be listed. Also, on the budget estimate, we have standard forms where we require the doctors and the hospitals to fill out. Now, Mr. Lee. Now, concerning the budget estimate of the service charge, Now, as Mr. Chen said, this is to provide the patient with an estimate of the eventual outlay for this non-emergency service or procedure. So the doctor or the hospital has to provide a budget estimate ahead of the surgery or procedure. Now, on this list, there are 30 procedures where such a budget estimate has to be provided. On the actual operation, very often before the patient is hospitalized, he would not have been in touch with private hospital, so usually it's the private doctor who fills out his own fee charged, and he will also make an estimate based on the information provided by the hospital on the fees to be charged by the hospital. So we say that 60% of the cases the information is provided. That is where both estimates are by the doctor and by the hospital's estimates of both the fees by the doctor and of the hospital are provided.
Can I supplement, Chairman? For the insurance sector, well, actually 90% of the hospital fees are covered by insurance policy. So please work together with the insurance sector so that patients get value for money and that the hospitals will not overcharge. Now, we just talk about budget estimates, but if the actual expenditure is way above the estimate, there is nothing we can do. So please, government, try to cooperate with the insurance sector to perfect the system further. Mr. Fong, yes, we will continue to talk to the insurance sector. Dr. Fernando Zhang, first round. Chairman, I understand that hospitals are subjected to the relevant laws, but for the two universities which run healthcare facilities, they will be exempted from the bill. I don't see why these are not covered. They are, in nature, private healthcare facilities, and they are indeed providing medical services, whether it's a day procedure center or other types of medical institutions or facilities. I am worried that some institutions or facilities can be exempted from the bill, and that's problematic. For the Polytechnic University, we don't have medical training, but we have training for allied health staff. And we have set up some ophthalmic clinics and companies. And if there is disparity in the regulation leading to disparity in the costs in the market, then there will be an incentive on the part of the private organizations to work together with universities, because that will drive down the operation costs. Now, in this day and age, university have to raise their own funds. And if they use the setting up of private healthcare facilities to raise funds, that will be problematic, because if this bill doesn't cover them, their operating costs may go down, and that is a problem. I really don't see why the two universities are not subject to the regulation of the bill. Can you explain further? We've been discussing the issue on the two universities all along. Maybe they can't give you an immediate answer. They have to seek further information. Mr. Fang, thank you, member, for your question. We are now talking about dentists and medical practitioners engaged in diagnosis and treatment. Now, if in polyol no dentist or doctor is involved, then it is not covered by the bill. For Hong Kong U and CU, if they set up healthcare facilities for teaching and research, we will provide exemption, provided that these are for teaching and research activities. So that's the rationale behind. But anyway, we've heard members' views. We will try to understand more about these 14 facilities. On, say, the clinical trial center, as referred to by member, that's obviously for research. So this is a clear-cut case. Anyway, we will go back and take a closer look, and then we'll come back in the next meeting to do more explanation. They may say it's a teaching activity, but then at the same time they're providing important services. Just this morning, we heard about what is happening on the Chinese medicine sphere, and it is said that there are many publicly owned CM clinics in our hospitals, and they are in fact a project collaborated by the NGOs, universities and hospitals. So it's very difficult to tell whether they are actually for teaching or for providing service. Maybe on the surface is for teaching purpose, but in reality they are providing services. So we are worried that the same scenario will happen here under this bill. This morning we were on CM, Chinese medicine, but the same logic applies to Western medicine facilities. We can understand if it is just purely for research purpose. But if these facilities are providing public service, then I have query on their exemption. All right, no particular supplement, but we will consider the members' views. Dr. Pierre Chan. Mr. Fong referred to the hospitals under a law on hospitals. And this is a private healthcare facilities bill, and it will regulate certain premises. In your paper, you refer to facilities related to the two universities. They're not covered under laws on hospitals, and they're not going to be covered by the bill. You have to be very clear about this. I am not saying that the hospitals are not regulated at all. Private hospitals are now being regulated. But then, by the latest proposal, these universities, hospitals are not regulated on both sides. Now, second, apart from these two universities, other universities are running clinics, their own university clinics. Are these in university clinics under regulation? And on this paper, FHCR 3/3231/16, it sets out clearly regulations on premises where dentists and doctors will carry out medical procedures, and there are some exemptions. For example, if a clinic comes with less than 3 registered doctors and they are registered by individual, a doctor, and not as a company, etc. Now, on the question of exemption, will it be the case that the exemption certificate has to be displayed in the premises which are being exempted? you talk about small practice clinics. They said that these will be exempted if their situation, as long as the status of the clinic remains unchanged. Now, for the two universities, i.e. CUHK and HKU, well, let me say this first. If HKU and CUHK run clinics not related to teaching and research, they will not be granted exemption. For clinics within the universities themselves, they will be subject to the regulation under this bill. They will not be exempted. Now, as for the actual operation of the exemption, whether there will be any exemption certificates, can I defer to Dr. Choi? Dr. Chu. Well, they can, if they have been licensed, then the license have to be displayed. Now, in Clause 107, it says that the director will direct the small practice clinics to display the relevant information for reference by the public. Okay, I would like to follow up on the earlier three questions. Mr. Fong referred to the tattoo numbing cream, and he would try to ascertain the situation and come back to us. Anyway, I would like to say something more about this. Dr. Lee said that a doctor may prescribe for a patient to buy the tattoo numbing cream, and that's okay. But then the tattoo, the eyebrow tattoo has to be regulated. So I think that's very strange. The administration must try to clarify the situation. A lot of exemptions are provided under the bill. Tattooing is exempted, but is not stated categorically in the paper. I think you have to deal with these special circumstances specially. Now, a lot of beauty parlors are providing eyebrow tattooing, and I don't think it's not totally unrelated to the bill. Now, if the doctor prescribes or performs this eyebrow tattooing in the beauty parlor, then the letter will be turned into a clinic. So you have to deal with all these specific cases as well. Now, can a doctor serve as the CMA of more clinics or beauty parlors? Mr. Fong said that he will study into the matter. There is a shortage of doctors in Hong Kong, so please consider seriously before you implement this measure. Now, thirdly, on the question of clinics, even if the doctor stays for 1 or 2 hours in that premise, the premise is deemed a clinic. And this is exactly the worries of the beauty industry. They're not happy with this measure or proposal, because for most of the time, a beauty parlor will provide beauty and massage services. Maybe just one patron or 2 patrons would seek such services. And as a result, the beauty parlor is turned into a clinic. Well, technology in our society develops in leaps and bounds, and there are so many new beauty services being provided. If such services are to be provided by doctors, then they will really threaten the survival of the beauty industry. And if they can afford the CMA, then that's okay. But then I'm asking that a doctor can serve as a CMA for more beauty salons. And also, if the beauty salon is very sizable in area, and If it has to provide more access because it is deemed a clinic, then that's okay. But then for smaller beauty parlors, and that is not very feasible, and we may see a spate of shutting down of the beauty parlors. Can I defer to Dr. Chui to talk about the operation of the beauty parlors and the access and so on, access requirements? If a member of the public uses a service, we want him or her to be able to differentiate clearly between medical services and non-medical services. And that's why we are asking for separate accesses for the relevant premises. Now, we've heard that there have been some concerns on this. We can study further into that. We just want to protect the consumers and so that they will not get confused. We are suggesting that medical services should be segregated from non-medical services in terms of their premises. The medical practitioners, in accordance with their own professional requirements, may have to perform certain things. And we are particularly concerned about the privacy of the patients, the storage of the medical records, and say if the doctors have to prescribe medicine, medicine has to be handled carefully.
This was our consideration, and the next member is not here now, so you can follow up. Now, the administration is saying that the separate entrance is for the public to be aware that this location is to engage in that kind of service. So you can actually post a larger sign and make clear that at this premises there is this kind of medical procedures being provided. Now, you don't have to get an engineer to open up another entrance. Now, you want the public to be aware, so you just make sure that they post clear signs. The signs would be affordable, and if they do get a doctor to administer this kind of injections, now the doctor is the executive for a number of premises, then the doctor will make sure that the premises would be clean and proper. So you let the public be aware, not just by means of a separate entrance. The public can see the notice or sign. So you don't need to make them alter the entrances physically. Now, we don't want to be in the way of this bill. Now, there are genuine clinics providing healthcare treatment for patients. We don't want to stop that. But the beauty parlors, they don't mainly engage in this kind of procedures. If they fail and close down, then in the future, beauty services will become very expensive. So would this evolve into regulation of beauty parlors? Now, as Mr. Shiu said, you don't have to require a separate entrance. You just have a larger sign. So would it be a kind of regulation of beauty parlor rather than regulation of medical healthcare establishment? Now, the premises may involve non-healthcare procedures, so the regulation will become more complicated. So why do you need separate entrance? Because we want to regulate a premises. Now, if you have a clear scope of regulation, that is helpful. Otherwise, it will be very complicated for the consumer, and even the staff might be confused unless you have a clear scope of regulation. Now, if the premises provides beauty services that involves a healthcare procedure, then we will regulate accordingly. Otherwise, enforcement will be difficult. Now, just now, the doctor said that a separate entrance is to enable the public to be clear about what service is provided at the premises. Now, so you don't rely on an entrance to tell people. Now, you can post a sign. You can attach a label stating that a doctor will come to administer injections. So this has nothing to do with the furnishing of the premises. Now, for this to be visible to the public, this is a consideration. Why do we need a separate entrance? When there is going to be a healthcare procedure, then there are licensing requirements. For instance, the equipment, the management of healthcare records, emergency procedures, and so on. So, apart from the public, the people working inside would also be protected if we make a clear delineation of the requirements. Now, what requirements will you have for the clinic? If it's to be a clinic, if a beauty parlor is going to have a clinic there, now what will be the requirements? Do you have requirement on the size, the equipment, the furniture? Now, we will not go into so much detail in the bill, but in the code of practice, those will be mentioned. Now, we won't actually specify the size of the furniture, but on emergency equipment, how medicine is to be stored, there has to be a room for diagnosis with a washing basin. Now, we will have those requirements. Now, we haven't issued the guidelines yet, but when we regulate clinics, we already have legislation on that, and the Department of Health has posted the requirements on its website. So in the future, the situation will be similar, so you can refer to that. And secondly, we are also working on the code of practice for the industry, and later we will provide members with a draft. Now, I have a question. Now, concerning separate entrance, of course, you want to make it clear to the public that this is premises for healthcare procedures, but separate entrance comes under the buildings ordinance and its regulations. Now, if a commercial premises leases and a location, and maybe a separate location is not permitted under building regulations, so the establishment might have to rent additional premises, and the cost will be increased. Now, how do you define a separate entrance? Now, maybe you can enter through the main entrance, and then there would be separate entrances within. would that be workable? Now, it might have rented several units, A, B, and C within the premises. So that room would be the regulated premises rather than the entire premises. So would you accept that? Am I making myself clear? We understand. But that was not our thinking. We want the public to be aware when they arrive at the premises, but we will think about this when we go back. In the past, there has been quite a lot of controversy on the deed of mutual covenant implications. Now, very often when there is remodeling of the premises, a separate entrance is not allowed. Maybe a plan would have to be submitted and the buildings department may not accept that. And very often the deed of mutual covenant doesn't agree, that does not permit that. Now, if you want to make this a requirement, you need to go back and do more work. Mr. Shiu Ka-fai? Now, on the earlier situation that I alluded to, now if a doctor is there to administer injections for 2 hours a week, then it becomes a clinic and it has a separate entrance. Now, can it be one company and it says it's a beauty parlor and it meets your requirement, so the company has 2 entrances? You walk into one, there is a hand basin and carts and so on, and can you and can it be lead then into the other side, which is a beauty parlor? Now, this is very specific. We will go back and consider the views. Now, what we want to achieve is clear regulation. Now, please take into account these scenarios. So in some premises, they don't allow 2 entrances, so you can go into one and you can then walk into the part that engages where this procedure is provided. Now, let them go back and work on it. Now, the questions have been repeated. Now, they may not be able to answer anyway today with Dr. Chen. Now, the questions asked by Mr. Shiu and by myself, now these are very practical matters. This is a new bill. Now, when there is new legislation, people will try to exploit loopholes. So in the drafting and scrutiny of the bill, we have to communicate carefully. Now, Mr. Shiu talked about doors within the main entrance, etc. Now, you talk about exemptions. Now, the spirit of the legislation is to regulate all the work done by doctors and dentists, and you provide some exemptions. Now, how would, under what circumstances would there be loopholes or gray areas? Now, suppose I'm a private doctor. I operate a clinic by myself. I apply for exemption. I'm exempted. So I'm a small practice clinic. Now, if I am also employed by a company or a syndicate, and it's the same clinic, then I wouldn't be exempted. Everything else is the same. but the signboard is changed, then I'm not exempted. What I do is not high risk. Then what is the basis? Now, someone does the same thing at the same premises, but the signboard is different, the employment terms are different, so one is exempted, the other is not. So how do you explain that? We thank Dr. Chen for his question. Now, in drafting the law, we look very carefully at specific possibilities. Now, on the entrances, we discussed that internally. We felt initially that we need to be strict, but having heard from the industry, we will try to see whether there is scope to provide greater assistance to the industry to meet licensing requirements. Now, on Dr. Chan's question, it's a very good question. We see there's a basic difference. Now, on one hand, the doctor is also the boss of the clinic. He's also the medical executive, the doctor for the clinic. In that case, the equipment and the entire operation of the clinic, the requirements on privacy, on emergency treatment, on medical records, on infection, all this he has to be responsible for because he is also the boss.
And if he is not the boss, he's being employed and he just goes there to see the patients. So these other requirements are not under his ambit, and he doesn't have full control over all these aspects I mentioned. So that's why we said that under the bill, the licensee has to be regulated, and the licensee has to meet with all the requirements related to clinics, and a CMA has to be appointed to ensure that their operations can meet with the licensing requirements. So there are two sets of considerations for both scenarios. Can I follow up? Say if a doctor establishes his own company and he runs this clinic himself, so what happens under the bill? The doctor sets up his own company and then he uses a company to hold the license. Well, that company is exempted. Can be a legal person or a natural person is exempted. The essence behind is whether this doctor has a full control over the operation of the clinic. If yes, well, what happens if there is a change in the shareholding? Well, the situation will be different if there is a different shareholder and the licensee has changed and he is purely employed in that clinic. Mr. Lee, can I add, for the exemption under small group practice, like what Mr. Fong said, we would be focusing on the operation and the management, whether this person has the full management over the clinic. If it is managed by a company, and if this is the doctor is the only director, then he has the full control of the clinic. That means he will be given exemption. It hinges on whether the shareholders or the doctors of this clinics. If yes, they will be granted exemption. Let me be more specific as to the implementation of the bill. The healthcare facilities have to apply for exemption letter from the DOH. A doctor may be very old and he is running his clinic on a part-time or half-time basis. So how can we help him to apply for a letter of exemption, or else he'll be subject to regulation? And how much information does he have to fill in to apply for exemption? How should we be helping these old doctors who are operating his clinic and provide service to the Kaifeng's residents in the neighborhood? So how much information is needed in the application? Can you be clearer on this aspect? Dr. Chiu, for small practice clinics, there is no deadline for application for exemption. That's different from how the transitional arrangements work. As long as the person is eligible, he can come forth and apply, and we will do more publicity and explain to the sector more. As to the form to be filled out, the requirements are not that stringent, so we will not be asking a lot of information on the form. We are now working on it. When we come to the individual clauses, we can present you with a preliminary draft of the form for members' reference. You said that there is no deadline, and then you would do more publicity. Can I follow up? If this doctor, because of his old age, he doesn't know about this, and he has not applied for a letter of exemption, will he be caught inadvertently by the law, and his operation does not meet with the requirements of the law? So would that be a vacuum period in which these doctors would be caught inadvertently by the law? Mr. Fong, we have issued letters to all registered medical practitioners in Hong Kong to let them know that the bill is coming up. We have notified them all. We will continue with our work, and when the bill takes effect, we will again issue perhaps letters to all registered doctors in Hong Kong to make sure that every doctor in Hong Kong receives the message. I think you should do more publicity. Actually, most of the doctors don't know that we are scrutinizing this bill, but we will do our best. We'll try to do more. Dr. Chiu, in terms of implementation, actually, we are also concerned that once the bill takes effect and everybody is required to take a license, a lot will be caught inadvertently. So we will be implementing the ordinance by phases. First, we will proceed with the registration of the clinics, and then later on, the sector will be more well aware of the bill, and they are meeting with the requirements, and then only after that will the administration will take people to task and hold them responsible. We will allow more time for the sector to get adjusted. Well, this is exactly what I am asking. You said that you didn't have a deadline. You don't have a deadline. I'm not blaming you. So how are you going to assist doctors who find it difficult to comply? There is no deadline for application for exemption. Say if a fresh graduate would like to practice, he or she can come to apply for exemption any time, so there is no deadline. Now, after the bill is passed, certain provisions have to take effect. Our initial idea is that we will first accept application for registration, and then depending on the situation, we will then decide on when we will, say, shut the gate, so to speak. And that is to tell people that if you don't apply for a license or you don't apply for an exemption, then you commit an offense. We will still have to come back to the legislature to seek your approval before we do that. Well, I don't get it. I would like to follow up. So I would like to get a very clear picture on how the ordinance will be implemented. I stand to be corrected. Now, after the bill is passed and the ordinance takes effect, say, if I am performing high-risk procedures, then I would definitely apply for a license and try to meet with all the requirements. That's category 1 doctors. And some doctors would like to apply for exemption, and they would apply for exemption right away. And the third type of doctors is that they don't apply for the license, and there is no deadline for application of exemption. So do you have a certain specified time period as to what people should do? Now, we would definitely ask you the questions on how many doctors have not applied for a license or applied for exemption. Now, Dr. Chu, you said that by a certain date, if you don't do these two things, then you would shut the gate and people will be held liable. And I really don't get the logic of your remarks, so I would like to find out more. Administration, did you understand what the question is? Let me try to give you the overriding principle. The member is asking about the specifics. Anyway, the overriding principle is that we don't want to see some doctors and dentists who are caught inadvertently by the law after the ordinance has taken effect. So that's why we are providing transitional provisions or arrangements in the bill so that the D of H will be empowered to decide on when certain actions will be taken. But they should come, say, either to apply for a license or apply for an exemption if they meet all these eligibility criteria. We want to retain certain flexibility. Say if 70 or 80% of the doctors have already taken action, then we will then shut the gate, so to speak, and it will be in the form of a commencement notice which has to be approved by the LegCo. So as to exactly how that works, we still have time and the room to discuss with the sector after the ordinance takes effect. We don't want any uncertainty, and we don't want to catch people want to see people caught inadvertently by the law. So what is the period? 3 months, 6 months, or what? We don't want to set a period now. There would be a demerit to it because we can't envisage there might be some complexity in relation to the applications and so on. So maybe we would first discuss with the sector before coming up with the indicators on the time frame, and then before we proceed with preparing the commencement notice. We are left with only 20 minutes, and is there any other member who wishes to ask a question? Dr. Chan, do you have a follow-up question? No? I think members have raised a lot of questions which have to be clarified by the administration. And if we need informal meetings to discuss further with the sector on certain issues, we are more than happy to help out. Now, if there is no further question, I would talk about the next meeting time is the 12th of December, 4:30 p.m. Does the administration have enough time to prepare all the information? Can you get that done? Yes. All right. So we'll have our next meeting on the 12th of December. Please mark it down. If we have further papers, we will issue them. If there is no further question and no AOB, meeting adjourned. Thank you very much.